YouTube feature is working. Mr. Forte, are you able to hear me?
Yes, Judge.
Great. Ms. Hall, can you hear me?
Yes, Your Honor.
Ms. Snyder?
Yes, Your Honor.
Great. Pixel 3, we're in a different spot. Hello, Ms. Patel.
Yes, Your Honor, I can hear you.
Okay. And Mr. Forte, were you able to hear Ms. Hall, Ms. Snyder, and Ms. Patel?
Yes, Judge.
Great. Success for a Monday morning, IT. Thank you for being here.
You're welcome.
Any update on making this printer talk to the computer, or is that Ms. LeBeau's project?
No, she took it over me. She's on vacation. I got to call Sharp. They were supposed to send their tech over because it's different to make it go to USB. I'm going to call them as soon as I get back to my desk.
Great. Thank you so much.
And you think you'll be here what time today?
This calendar, I have another hearing at 1.
Right.
So I'm here most of the day.
But if you finish between now and 1, just email me and I can see if I can get them to come over.
Okay, they could come over during the hearing. That's okay. I just didn't get it fixed. So if they say they can come at 10, just tell me they're coming at 10.
Okay, go ahead.
Thank you so much.
You're welcome.
All right, we have one of our jail Zoom calendars, and I will ask my colleagues with the sheriff's office, are we going to go through the calendar in the order in which it was published, or do you need us to go in a different order?
First on the calendar is Mr. Millender, Terry Millender, sir.
Yep. So you want me to tell you the order of the calendar, or you all plan to go in the order it was published?
I'm not quite sure, but once I get over to the jail side, I will let you know. But right now I'm at the Marietta Annex.
Okay. Well, Mr. Millender happens to be the first one, so that makes it easy. So we'll work through the calendar, ideally in the order in which it was published, but we'll defer to the folks at the different jail facilities. They may have an order in which they need to do it. So the first position is Mr. Millender, and I'll let you know, Mr. Forte, if and when we need to take things down. Mr. Millender, can you hear me?
Yes, sir.
Great. I'm Judge McBurney. Your case has been assigned to my division, and it looks like we are handling plea and arraignment for you. Ms. Patel, I've got down that you and Mr. Millender are working together.
Yes, Your Honor.
Okay, and am I correct that what we're doing today is handling what Mr. Millender wants to do with arraignment?
Your Honor, the state and I have a negotiated resolution on this case, and so we are prepared to enter a plea. I just need to communicate to Mr. Millender the logistics of the sentence.
So if I move you and Mr. Millender into a breakout room, you guys can have a few minutes to work through that?
Yes, Your Honor, it should be very quick.
Okay, you take the time you need. It's an important event for Mr. Millender. Ms. Hall, would this be a plea to the indictment as charged, or is it a reduction?
It'll be a plea to the indictment as charged, Your Honor.
Okay, I'll work on getting a copy of the indictment. Mr. Millender, in just a moment, I'm going to move, not you physically, but digitally. You're going to move to a place where it's only you and Ms. Patel. The two of you can speak privately. None of the rest of us can hear what you're discussing. So it would be as if Ms. Patel was there at the Marietta Annex with you. She's going to share with you her thoughts about your case. You can ask her whatever you want. And when you two are done, you'll come back to this large group setting where once again we can hear you. Does that make sense?
Yes, sir.
Okay, I'm going to try to make this breakout room thing work. Let's see what happens. Breakout room 1. Pixel 3. All right. Mr. Millender, someone with you may need to push a button on the computer to get you into that.
I don't see it right now, sir.
Make sure you say yes, okay?
Joining.
Thank you. So courtroom 2, I don't know if you guys are up and ready. We have a quick minute if you've got someone ready, but I'm also fine just waiting to wrap up Mr. Millender.
We have some claims. I don't know I don't have a calendar, so I don't know who is next. Can you tell me?
The next here says Kendrick Lewis.
It's
Is
Ms. Patel.
Lewis back here? No. We don't have that position.
Okay. How about Gregory Gordon?
We also do not have that one. I'm
All
sorry.
right, Rodney Knowles.
Let me try to tell you who I got. Hold on.
Okay.
So I have Gordon, Walker, what's your name was? Turner, and Morgan. I don't know if you need any of those. But
Got it. Well, what if we did Morgan? I think that's Ms. Snyder's client.
all right, come on up here, Mr. Morgan.
Hi, are you Mr. Morgan?
Yes, sir.
Great, I'm Judge McBurney. Your case is in my division, and you should see on the screen there Ms. Snyder, that's your attorney.
Yes, ma'am.
She may wave, she may just smile, but hopefully you recognize that, she gave you a wave. I've got down here that we were supposed to connect back in late March for plea and arraignment, and then public health things arose, and we've got you here to figure out what we're doing with your case sort of at its inception, the plea and arraignment level. Ms. Snyder, tell me what's happening with Mr. Morgan today.
This will be his plea and arraignment. As you said, I have a waiver of arraignment filled out and ready to file. I've talked to Ms. Hall about the discovery that we're missing. And then after speaking with Mr. Morgan this weekend, I'm going to speak to Ms. Hall about a BHTC referral.
Okay. What kinds of things do you feel like you're missing from discovery?
She previously served me with a body cam, but it didn't get saved to my computer, and now the link has expired, so she has to reorder that. And there is a video from a Publix that is mentioned in the police report that I've asked for.
Okay. Well, Ms. Hall, thank you for getting that to Ms. Snyder the first time. Hopefully it's not a hassle. Ms. Hall, Ms. Snyder thinks that the case is ready for a scheduling order. Can you hear me?
I can't, like, it was a lot of static when you started talking, but try it one more time.
Ms. Snyder was saying that her client's going to waive arraignment in her a scheduling order. Is that where you think we're going with the case?
I'm sorry, Your Honor. I heard you say Ms. Snyder said that she's waiving arraignment, and then I didn't hear what you said after that.
And then we'll enter a scheduling order.
Oh, okay. Yes, Your Honor. There is a body cam that I need to reorder. Well, I have it on my computer, but it was too large to email it to Ms. Snyder. But it's faster for me to just reorder it and send her the link again. So I'm going to do that, as well as I've already reached out to the investigative officer for the actual Publix video. So I'll get her those things. But yes, my expectation is for it to have a scheduling order and for us to just proceed as usual.
Great, works for me. Mr. Morgan, do you have any questions right now? I know your case feels old, but we're at an early phase. It's your first time appearing in virtual court in connection with all this. But Ms. Snyder's going to get more of the materials in your case, and then she'll keep talking with you and the prosecutor about what's going on. Does that make sense?
Yes, sir.
All right, Ms. Snyder, anything else for Mr. Morgan?
No, sir.
You will get the waiver of arraignment form to Ms. Nelson.
Yes, sir. I'll file it as soon as we're done.
Okay, thank you. All right, courtroom 2. What was another one of the names you said you had?
He also brought in 3 more people just now. So what was that position you said was number 2 again?
I don't want to do number 2 because that lawyer may not be available.
Okay. What about number 3 then?
3, same issue for,
okay.
Hold on a sec. I'm looking.
Keep going down the calendar. We got everybody.
Okay, so you got Thompson?
Yeah.
We're bringing him up.
Mr. Franklin, is Arthur Thompson your case?
Hopefully he is not. State your name, sir.
Arthur Thompson.
You gotta talk
Hey,
loud.
Mr. Thompson, can you hear me?
Yes, sir.
My name is Judge McBurney. Your case is in my division. I'm trying to figure out if your lawyer, Mr. Franklin, is able to hear us, making sure he is your attorney.
I can hear y'all.
You see his face there? You recognize the guy?
Yes, sir.
All right. Well, we're trying to get him to connect with us.
You haven't said nothing.
Well, that's a screenshot.
Oh.
Hey, Mr. Franklin, you out there?
Hey, could I come back? I gotta use the bathroom, man. Cause he ain't out there.
We're just gonna give him a second. He may be having some technical difficulties.
All right. See, he ain't coming up. He's there on the phone, but he ain't showing up. Yeah.
Let me tell you.
That's what he said. He's gonna see me in 2 seconds.
Your Honor, he has to use the restroom. Can he run and use the restroom?
Yeah, he can go use the restroom.
Okay.
Sorry about that. Ms. Snyder, do you have any other cases on the calendar?
Morning.
Yes, sir. Position 8, Mr. Walker.
Okay. Hey, are you William Walker?
Sir.
Can you hear me?
Yes, sir.
Okay, good morning. I'm Judge McBurney. We are going to talk a little bit about your case today. Your attorney, Ms. Snyder, is on this call as well. On my screen, she's right next to you. I don't know where she is on your screen. Mr. Walker, we need to figure out what we can do to move your case along today. This is your plea and arraignment date. Ms. Snyder, what are you hoping to do today?
Your Honor, I've prepared a waiver of arraignment. I just need to speak with Ms. Nelson about doing a change of address form. And I've spoke to Ms. Hall last week about the discovery that we're missing. I have the initial packet. We just need some digital stuff. So a scheduling order would be appropriate.
Okay. Seems like things you should be able to get, or is there anything that looks complicated?
Body cam, dash cam, radio chatter, a use of force report, license plate, reader hit.
The basic stuff.
Yes, sir.
Okay. All right. Ms. Hall, any reason we need extra time in this scheduling order, or is the standard time workable in this case?
The standard time is fine, Your Honor.
Okay. So you're going to file the waiver of arraignment form after we're done today, Ms. Snyder?
Yes, sir.
Mr. Walker, Ms. Snyder's going to file a little paperwork on your behalf, and she's going to then ask for and hopefully soon receive the rest of the discovery in your case, which she needs to see, and she'll need to discuss with you to figure out if there are motions to file or what this case looks like beyond what's just in police reports. So she's going to get her hands on that, and then she'll be in touch with you. Do you have any questions for me, Mr. Walker?
No, sir.
Okay, well, we'll keep moving your case along. And if we need to get you back on this screen, like in this courtroom for a hearing, we'll make sure that happens, okay?
Yes, sir.
All right, thank you. All right, it looks like our friend, Mr. Millender, is back from the Marietta Annex. Ms. Patel, can you hear me?
Yes, Your Honor.
Are you ready to go forward?
Yes, Your Honor.
All right, Ms. Hall. There she is. Are you ready to go forward?
Yes, Your Honor.
Okay. Mr. Forte, you ready? Mr. Millender,
Yes,
are
sir.
you ready to go forward with entering a plea in your case?
Yes, sir.
For us to do that, you need to be put under oath by Ms. Hall, but before she swears you in, I need to ask you a couple questions about your rights as a defendant. One right that you have is to be here in open court, but you're at the Marietta Annex right now. You waive your right to appear in open court, and are you willing to proceed remotely like this?
Yes, sir.
Another important right you have is to have your lawyer by your side, Ms. Patel sitting right next to you, so that if you have questions or concerns, you can lean over and ask her those questions. But that's not how it works today. Do you understand that?
Yes, sir.
Do you waive your right to have Ms. Patel by your side during this case?
Yes, sir. Yes, sir.
Do you understand, Mr. Millender, that if at any time you want to speak with Ms. Patel, you just need to let me know, raise your hand or do something, and we'll put you in that breakout room just like you were, so you can have a private, confidential conversation with Ms. Patel, okay?
Yes, sir.
That's going to be how we do it. And if at any point you cannot hear what someone is saying, raise your hand as well so that we repeat whatever we said, all right?
Yes, sir.
Great. Okay, Ms. Hall.
Thank you. Mr. Millender, sorry. Can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may raise your hand. Please state your true, correct, and legal name.
Terry Millender.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Would you say, Mr. Millender?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 51. I'm 50 years old. I'm in the 10th grade.
And are you able to read, write, and understand the English language?
Yes, ma'am. Yes, ma'am.
Do you understand that you have been charged with theft by receiving stolen property?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to that charge? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Patel, about all the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So waive.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Waive for the purpose of this plea only.
And do you waive moving forward on a copy of the indictment?
We waive.
Mr. Millender, have you been arrested on these charges?
Yes.
I ask because the state is unaware of any outstanding warrants that are related to this charge. Do you or your attorney know of any outstanding warrants that are related to this charge?
We do not.
Mr. Millender, has your attorney advised you of the minimum and maximum sentence to the charge that you're pleading to?
Yes, ma'am.
The minimum and maximum sentence for theft by receiving stolen property is 1 to 10 years to serve. Mr. Millender, do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 3 years to serve 6 months, balance suspended, no restitution in this case, conditional that you return to Ohio, but the court does not have to accept that recommendation. The court can sentence you to the maximum on this charge, which is the 10 years to serve. Do you understand?
Yes, ma'am.
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison? What'd you say, Mr. Millender?
Yes, ma'am.
Thank you. Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of the discharge after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the single charge of theft by receiving stolen property in indictment number 19 SC 166519?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand that you have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, the state is aware of, the defendant has several prior felony convictions, 3 of which out of Georgia, the state of Georgia. The remaining convictions are out of the state of Ohio, dating back to the 90s. If you would like for me to list those, Your Honor, I will.
Why don't you tell me the 2 most recent?
Okay. The 2 most recent that I have are from Ohio, a drug possession out of Ohio, disposition date of, August the 29th, 2014, and aggravated assault out of Ohio, disposition date of September the 30th, 2014. The cases that were received back in Georgia were the ones that were in 89, 91, and 97.
Okay. Thank you.
You're welcome.
Proper,
Yeah.
Mr. Millender had any open cases here in Georgia?
Judge, he has no open cases in Georgia.
Okay, thank you.
And Your Honor, had this case proceeded to trial, the state would have proven that on July the 25th, 2018, at 3131 Campbellton Road, Atlanta, Georgia, in Fulton County, officers responded to that location, which is affordable furniture. Upon arrival, officers spoke with the victim, Ms. Noonan, who reported that she discovered a U-Haul lockbox had been damaged and open. During investigation, Your Honor, officers were able to inquire about a vehicle, a truck that was reported stolen. Ms. Noonan advised officers that the keys to that particular truck was put into the lockbox, and apparently someone got into the lockbox, got those keys, and took that vehicle. On the 14th, this was reported on the 14th of July, and on the 25th of July, the defendant was found driving that U-Haul. Officers asked him as to where he got it from. He could not give that information. He was arrested and charged with theft by receiving stolen vehicle. This is a case we have been trying to work out since the beginning of COVID, Your Honor. There was originally the issue that we were hanging up on was the restitution amount. And I've had several conversations with the victim over a month span trying to get this amount, and I still have been unsuccessful in her giving me, not unsuccessful as talking to her, but unsuccessful as getting that amount. And it's pretty much what's holding up this case. That's why I said no restitution. And that's all from the state, Your Honor.
Thank you. So Ms. Newman, and that's Newman.
Yes.
Was she unable to give you a dollar amount, or she was unable to provide proof of the dollar amount?
Both, Your Honor.
Okay. So you tried and she couldn't do it.
Yes.
But she did get the truck back. It's just her claim that the truck was not in as good a shape as it was when she lost the truck.
Correct.
Okay.
And she did say it was repaired, but she owns Affordable Furniture, and U-Haul is kind of like a side operation. And so it was handled through the corporate location. So it's not something that really even came directly from her funds. So I think that it wasn't beneficial for her to get me a number.
Got it. All right, Ms. Patel.
Thank you, Your Honor. This was a case that we discussed before, Your Honor, and Ms. Hall is correct that Your Honor had indicated that, should Mr. Millender be able to pay off his restitution, that we could schedule it, have him plea, get him out as soon as possible. And it just seems that this complaining witness has not been cooperative with Ms. Hall in terms of getting her that information. If Your Honor recalls, Mr. Millender comes from Ohio. He lives there with his mother. Before he was arrested on this extradition warrant, he was doing really well in life. He was working for Flambeau Plastics, which is a full-time job. I spoke to his manager there. He had all good things to say about Mr. Millender, said that he was a great employee, that they were sad to see him, get tied up with the issue in Georgia, and that they're hoping that they can take him back. With COVID, things have changed for them a lot. But with things slowly reopening, they said that Mr. Millender, they'd be happy to see him reapply, and hopefully he can maintain employment once he goes back. He, in speaking to his mother, they have a very close relationship. She said that Atlanta has not been great for Mr. Millender, that he was falling into the wrong crowd, but that she has seen him make a huge change in his lifestyle decisions, the company that he keeps, that he has been doing really well in life, and that she's proud for how far he's come. I've been in touch with his mom about how they would get him back to Ohio. She has been saving the money for a Greyhound ticket, so she has that. We just didn't know when Mr. Millender would be released, and so it was really difficult for us to plan anything that far ahead in terms of when we could assure his release. We are asking that he be allowed to go back. The reason we're asking for the suspended sentence is that we don't think that it would be ideal for him to be on probation in Georgia. And I think that he doesn't really have any plans to come back. He's doing well in Ohio. And so he's not trying to mess up a good thing that he has going for him. Your Honor, I would ask in terms of where his time served would start. He did serve sometime in 2018. So from July 26th, 2018 to July 30th, 2018. And then he was initially arrested in Ohio, March 12th of 2020 on this case. And then he was extradited to Fulton County, where they received him, I believe, March, let me see.
23rd when I came to Fulton County, March 23rd.
Right. Yes, March 23rd is when Fulton County received him from Ohio.
Okay, so in terms of 6 months, he's already done, just since the arrest in Ohio on the warrant from here, he's done 5 months and a little bit, and then you're saying add the 5 more days for the time that Mr. Millender was in until he bonded out.
Correct.
Okay. All right. Mr. Millender, what's your Georgia connection? It sounds like mom is in Ohio. What brings you to Atlanta?
My stepfather lives here, and my cousin, but I've been here, I moved here when I was 5 years old, so I've been, you know, a citizen of Atlanta pretty much all my life, but Ohio is where I'm born at, you know, so I basically went back there to get my life back going and got my life back started.
When was it that you went back to Ohio?
Excuse me, sir?
When did you, so I understand you were born in Ohio and you came here. When did you go back to Ohio?
I've been going back pretty much back and forth all my life since I was 5 years old, since I moved to Atlanta when I was 5, you know.
Okay. Where in Ohio?
Akron, Ohio.
Akron. Okay.
Yes, sir.
All right. But you get it now that the plan is for you to stay in Ohio and not go back and forth.
Yes.
All right. Tell me how you got your hands on this truck.
I was working for a guy, pulled up on me, and I was sitting on the corner. The guy asked me, do I want to move some furniture, help him out? I said yes, you know. Basically, that's how it happened.
Okay, I think you may have told me that before, that you were going to make a little money helping this guy.
Right, exactly, sir.
He had the truck already.
Exactly.
Okay, got it. Okay, Mr. Millender, do you have any questions about what we've talked about so far?
No, pretty much understand.
Okay, you say pretty much. Anything you don't understand?
No, I understand.
Okay, it's fine if you've got a question, but if you're good to go, I find there is a factual basis for your plea. You were driving a truck that had been stolen and wasn't yours, and you sort of just hopped in it. I understand why you would have thought that this other guy wouldn't be driving the stolen truck, but it doesn't make the truck unstolen.
Right.
I also find that your plea is knowing and voluntary. Knowing means you've understood the things we've been talking about, and if you didn't, you let us know. Is that a fair statement?
Yes, sir.
A voluntary plea is one that you make of your own free will, meaning no one's forcing you to enter this plea, and that the only promise you've received is what it is that the state's recommending for your sentence. Is that true?
Yes, sir.
All right, so you want to go forward with the plea?
Yes, sir.
All right, then I'm going to accept your plea, Mr. Millender, and I will, for the most part, follow the recommendation of the parties. I'm going to make the math easier for everyone. I'm going to sentence you to 3 years to serve 5 months and 1 week. You've already done that, so we don't have to worry about where they start the math.
Okay.
I think the recommendation was perfectly reasonable, to be clear. But this way, you're going to get out today or tomorrow, and hopefully you'll get on that Greyhound bus. And
I will. I will.
There's no restitution, but I am adding as a special condition of your sentence, Mr. Millender, that you are banned from the state of Georgia, except for the Waycross Judicial Circuit. That's W-A-Y-C-R-O-S-S. In case you're wondering where Waycross is, that's way down in southeastern Georgia. It's Coffee, Bacon, Pierce, Ware, Brantley, and Charlton County. So
Don't want to,
down near Florida. If you don't know where that is, don't worry about it, but that's where you could go in Georgia if you gotta come back.
okay, I was going, I said, the reason why I was banned, I mean, I do have family here, Your Honor, you know, and I was just understanding the band situation. I can never come back to Atlanta and visit none of my family?
No, that's not right. It's just as long as your sentence is going. So you've got 2.5 years left of your sentence.
Okay, I
2.5
understand.
years. Don't come to Atlanta.
Okay, I got
you. Macon.
No problem.
You can go down to those counties I mentioned. If you've got family in Bacon County, you can go there.
Okay, I got you. I understand, sir.
So you'll just want to do the math. 2.5 years from now, it'll be safer to travel anyway, one hopes. Then you can be back. But while your sentence is running, it's important that you not come back to the metro Atlanta area, because if you got pulled over for a speeding ticket, the state could try to revoke the balance of your sentence. And so if this let's say you came here for Christmas because you wanted to see family, you're gonna have 2 years left on your sentence. And you could end up spending those 2 years in custody just because you came back to Atlanta. So be smart about that, okay?
All right.
All right, and of course, family can come visit you. You can call and write and FaceTime people, but as long as that the remaining 2.5 years is running, you need to stay out of the metro Atlanta area.
I understand, sir.
Judge, I have a question on that sentence.
Ms. Nelson?
You said 3 years to serve, 5 months and 1 week. Is the balance suspended?
Yes, it is.
Okay, thank you.
Balance is suspended. And Mr. Millender, if you were here in the court, you would sign the indictment in your case, and Ms. Patel would sign it, and I have the process actually of an accusation, not an indictment. But same thing, a document. Do you authorize me, Mr. Millender, to sign on your behalf since you can't sign it today?
Yes, sir.
Ms. Patel?
Yes, Your Honor.
All right, Ms. Hall? Ms. Hall took a quick break. When she comes back, I'll ask her, but the prosecutor's supposed to sign the accusation as well. If she gives me the green light, then I'll sign that paperwork. Well, I'll also sign your sentence today, Mr. Millender, so you should be released in the next day or so. If it's Wednesday and you're still there, you should reach out to Ms. Patel, and she'll reach out to me, and we'll figure out why you're stuck.
All right, thank you, sir.
You have any other holds? You in trouble anywhere else?
No, sir.
All right. Well, I hope we get you back to Akron, Ohio, so you can be with family there. All right.
Right. Thank you, Don.
Get out of trouble.
You know it.
Ms. Hall, do you authorize me to sign the indictment on your behalf?
Yes, Your Honor.
Great. I'll do that. Ms. Patel, anything else for Mr. Millender?
No, Your Honor.
That's it. Thank you, sir.
Patel.
Thank you. Mhm.
All right.
You can come up here. Yeah.
I can't come in here.
Oh, you can't get in?
I'm gonna put the statement in.
Hold on one second.
Take a break.
Would you like me to take a break?
Okay, that's a break, yeah.
Okay. I gotta get sworn, wrapped in by another deputy, so I'm gonna step off the bench for about a minute or less. We'll take care of that. And then Mr. Lewis ideally will be next from courtroom 2.
Got you, Your Honor, Mr. Lewis. I have him ready.
The sharp folks say they come, right?
I'm waiting for the call, guys.
Okay. I don't see they tried a bunch of things.
All right. Superior Court of Fulton County, Atlanta Judicial Circuit is now in session. Honorable Judge Robert McBurney presiding. Court will come to order.
Thank you. Please be seated. All right, let's turn to position 2 on our calendar, which is Kendrick Lewis. Are you Mr. Lewis?
Yes, sir.
How you doing this morning?
Doing good, sir. How about you?
I'm all right, all things considered, complicated times. Mr. Franklin, is this your case?
No, Your Honor, it's my case.
Oh, okay. Oh, that's right, it's a 6. Okay, so Ms. This is on for an inquiry. It looks like Mr. Lewis got picked up on a warrant. So we need to make sure discovery is flowing, and talk a little bit about whether you expect Ms. Patel to file any motions. And then I also see a note that Mr. Lewis has a whole bunch of state court cases as well, which is really neither here nor there, although you may want to sort those out additionally. How are you doing with discovery, Ms. Patel?
Your Honor, I spoke to Ms. Hall and I do need a discovery packet, and I believe she had put the request into her administrative assistant.
Okay, so you don't know yet, because you haven't seen much about the case, whether this is a case where we'll have any evidentiary hearings pre-trial.
Correct, hard to say now.
Okay, all right. Ms. Hall, tell me where you are in the process of tracking down discovery.
Your Honor, I have ordered the discovery. Beyond that, this is a case that me and Ms. Patel have been talking about, possibly negotiating a resolution. So I have requested the discovery. I just haven't been aggressive with it, with it returning to us. But the request is out there, Your Honor. I do expect for it to come in soon, and I'll get that over to defense counsel. We may have a resolution before we have all the discovery, though.
Okay. Do you know, does the discovery include anything tricky for you to get your hands on, like a video from a gas station, or is it the standard fare of it's going to be body cam and 911, that kind of thing?
Just regular body cam 911, nothing other than the usual stuff.
Okay, got it. Then, Ms. Nelson, do we have a scheduling order in place, or that's what we were going to talk about today?
Let me check, Judge.
Ms. Nelson has a dog.
And some of this I took care of. I just called her about it.
Okay. Oh, you have been talking.
Yeah, I just called. So.
Okay, not her dog.
No.
Okay.
Okay, good.
And Your Honor, there shouldn't be a scheduling order because this is the first time he's been arrested on this case. It was upgraded from state court.
Okay.
And so our plan was to, the state has offered a drug court track 1 referral. And so we're requesting to be heard on bond while we move forward with the referral process through drug court.
Yes, that's correct. There's no scheduling order, Judge.
Okay. So should we also do a waiver of arraignment?
Yes, Your Honor, and I will send that to Ms. Nelson as soon as I type one up.
Okay, and you mentioned bond, Ms. Patel. Certainly, Mr. Lewis is entitled to be heard on that. Was that something you and Ms. Hall talked about doing today, or that would be the next step in Mr. Lewis's case?
We discussed doing it today.
Okay. Ms. Hall, are you in a position to argue bond today, or do you need time to reach out to the victim in the matter?
Your Honor, I'm prepared to argue bond. I'm not really going to argue against it since we're thinking about the track 1. And what me and Ms. Patel talked about was him possibly being released on bond and having his interview with drug court while he's home. I've spoken with the victim. Ms. Rolak has spoken with the victim. She's currently with child. I didn't ask whether it was his or not. It wasn't my business, but I do know she's welcoming him back. So I'm assuming. But with all that being said, I'm not arguing against bond because of the circumstances. So I'm prepared to move forward with bond.
Okay. Do we know if the state court cases, there are these 3 other state court cases, if they are connected in any way to Ms. Hendricks? That's the complaint in this case.
I believe they're all shoplifting cases, Your Honor.
So that's three different shopliftings?
Yes. They're just, I I believe they're all just alcohol drink shopliftings, which is why we think drug court would be appropriate.
Okay. And Ms. Hendricks, well, let's just do the bond hearing because you'll be able to get that on the record. That's all. I just taking a look at the indictment. All right. So, Mr. Lewis, you've been listening patiently. A few things are going to happen. One, Ms. Patel is going to fill out some paperwork that will get your case starting to move. She's going to fill out a waiver of arraignment. We'll get a scheduling order entered in your case, although it sounds like you may be interested in participating in the court, which, if you're accepted, could be a good thing. The charges are a little complicated for drug court, but I guess that's something, Ms. Patel, that you and Mr. Lewis will be talking to drug court about. And finally, we're going to talk about bond. We're going to do that right now. Mr. Forte, are you ready?
Ready, Judge.
All right, so this is 19 SC 170816. State versus Kendrick Jerome Lewis. Mr. Lewis is charged with aggravated battery, and misdemeanor obstruction of law enforcement. Ms. Patel, tell me why you think Mr. Lewis is a good candidate for bond.
Thank you, Your Honor. So the aggravated battery count, and I won't try to get into facts too much, but it just has to do with complaining witness's shoulder being dislocated. When I spoke to her, she's had her shoulder dislocated previously. And so when he pulled her arm, it was easy for it to pop out. And since then, it's popped out before, which is a common thing that happens when an individual dislocates their shoulder for the first time. With that being said, they are expecting a child together. She said that he's been doing really well. They haven't had any fights. He hasn't put his hands on her since this incident, and that she does believe that he does have a drinking problem that he needs to have taken care of. If he were to be released, Your Honor, we would ask that he be able to reside with her. She lives at 127 Nottingham Way in Ocilla, Georgia, which would at least have him, what she calls is the country, would have him away from Atlanta while we're waiting for him to get into drug court. I think that would be a good environment for him so that he's not potentially surrounding himself with the same influences as before. He is a lifelong Atlanta resident. I don't believe we'd have any risk of him not coming to court. And so we are hopeful that we can work this out with a drug court track 1 referral, and that he is accepted into the program. And so what we'd request is pre-trial level 1 reporting, and we're asking for the level 1 reporting since Ocilla is far away. It would be difficult for pre-trial to do the level 3 reporting with someone that doesn't live within Atlanta, and so at least he could check in with them once a week or I believe it's once a week on level 1, but.
Okay. What is the thinking, Ms. Patel, about drug court and Ocilla, by which I mean if Mr. Lewis were accepted into Fulton County Drug Court, there's no way he could live in Ocilla. Of course, drug court can help with housing, but he wouldn't be able to be down in Ocilla with Ms. Hendricks. And of course, drug court is 18, 24 months. So I want to make sure people are going in with eyes wide open about what that would mean.
Right. So he does have a mother who lives in Atlanta. She lives at 520 Holly Street, Atlanta, Georgia. So if he does get into the program, the idea would be that he, while he's in the program, goes back to residing with his mother while he tries to complete the program.
Okay. Ms. Hall?
Thought I was on mute. Thank you, Your Honor. I want to first start by saying that the victim is on the line with Ms. Rolak, and if at the court's pleasure, she can speak through Ms. Rolak or speak through speakerphone with Ms. Rolak if you are able to hear her. She'll like to speak on the matter, and that way I don't have to explain how she feels. She can explain it to you herself.
Okay, but you, Ms. Hall, as the representative of the state, do not have concerns about Mr. Lewis, number one, getting a bond, and then number two, at least temporarily residing with the alleged victim in the case?
No, Your Honor.
Okay, all right. Ms. Rolak, is Ms. Hendricks in a position to be heard technically, or are you going to speak on her behalf?
I'm not sure if you will be able to hear. Good morning, Judge.
Good morning. Yeah, and I don't want to make it a stretch for the court reporter. So how about I ask a couple questions and you can ask Ms. Hendricks and let me know what she has to say. And then if there's something she wants to add, she could relay that through you. Is that okay?
Yes, Judge.
All right. So of course, the most important question is, how is Ms. Hendricks doing? She's expecting a child. When is the child due?
How are you doing? And when is the child due? Mr. Forte, were you able to hear?
Yes, okay. November the 14th, and I'm
It's okay, I'll say.
Okay.
I am doing well, and baby is due November the 14th.
Okay. And Ms. Hendricks, are you comfortable having Mr. Lewis return to your household?
Okay.
Are you comfortable with Mr. Lewis returning to your household?
Yes, sir. Yes, sir. He will be here. He will be from here to Atlanta. I have a car, so I will make sure on his day if he has to go to court or get custody time to go to court, I will make sure he'll be in Atlanta at that time.
Yes, Judge, I'm able to do that. I have a car. I will make sure that he goes to court whenever he needs to.
How long is the drive from Osceola to Atlanta?
How long is the drive from Osceola
to? Like 2 hours.
It is like 2 hours.
Wow, you must be driving like 2.5 hours.
Hold on. Sorry, Judge. She was speaking at the same time.
Okay. That she must have a very fast car. Okay.
You must have a very fast car.
No, I would need to know the court date ahead of time. Before, I'm gonna have to know when you have to be in court ahead of time. So hopefully the paperwork will come to my house so he can know, so I can make sure he's there before, the day of court.
Okay.
Before the day of court.
Okay. I just wanted to make sure that I know ahead of time the days that he will have to come to court so that I can get him there.
Okay. Ms. Patel, how do you envision Mr. Lewis having an intake interview with drug court?
So, Your Honor, right now they're doing phone interviews. And fortunately, if he does live with Ms. Hendricks, she has been really easy to communicate with. So I would give them her phone number to arrange for the interview. And so hopefully that will speed things along a lot faster than it has been to get people that are in custody interviewed.
Sure. Okay. Mr. Lewis, tell me why you think going back to be with Ms. Hendricks is a smart environment for you between now and the time you might start drug court.
I'm trying to stay away from all the drugs and all that. Then I'm trying to be around my child. I'm trying to do the right thing. I'm going with my life, Your Honor.
I'm not sure who's the best person to answer this. It may be Ms. Hendricks, it may be Ms. Patel, maybe Mr. Lewis. But this case happened in June of last year, so only about a year ago, but it happened in Atlanta. And Ms. Hendricks is way down in Osceola now. Did you both used to live here in Atlanta, Mr. Lewis?
Yes.
Okay. And then Ms. Hendricks moved down to Osceola?
Yes.
Have you ever lived in Osceola?
No, sir.
You ever been to Osceola?
No, sir.
Okay. It's different from Atlanta.
All right.
All right. Ms. Patel, what is a reasonable deadline to put as a condition in the bond for Mr. Lewis to have completed his drug court intake interview?
I would say I would give it a month. It has at least taken, I would say, at least 2 weeks to even get a case on their radar in terms of an interview. But I think that once I reach out, provide all the contact information, as well as Miss Contressa also has an email address, I think that should expedite things in terms of setting up an interview.
Okay. Mr. Lewis, do you and Ms. Hendricks have any kids together?
She's pregnant with my child now, sir.
Would that be the first child you have with her?
Yes, sir.
Do you have any other kids?
Yes, I got 7 more kids, sir.
7?
Yeah, I got 3 sets of twins, 2 boys and 5 girls.
You make a lot of twins. Are the other kids all here in Atlanta?
Yes, sir.
But you'll go down to Osceola?
Yes.
Okay. How young is your youngest kid?
They're 11 years old, sir.
How old is your oldest kid?
My oldest son, he's 19 years old.
So you got 7 kids between 11 and 19?
Yes.
Okay. Do you work?
Yes, I'm trying to find me another job now, sir, when I get out.
What was the last job you had?
I'm working at the car wash, sir.
In Atlanta?
Yes.
Okay. Well, maybe they have a car wash in Osceola, but I wouldn't bank on it. All right. Are you asking for a signature bond, Ms. Patel, or just a low bond that can be made?
Your Honor, I'm asking for a signature bond through pretrial services.
Okay. And Ms. Hall, you do not oppose that?
No, as long as I think first she said level 3. That means he'll be monitored more. I'm fine with that, Your Honor.
She said level 1.
Level 1.
Because
Okay.
he's going to be in Osceola. I think level 3, you are reporting to pretrial supervision very frequently, which is hard to do from Osceola.
Yeah, my misunderstanding, Your Honor. Level 1 is fine.
Okay. Ms. Patel, do you have the new drug court or accountability court referral form?
I do, Your Honor.
So you'll get that signed, or at least you'll sign it. And then importantly, Ms. Hall needs to sign that. It's going to be what we don't call them tracks anymore. That's going to stick with it for a while. But this would be a diversionary referral. For a diversionary referral, the prosecutor's got to sign it, or they won't start to process it with accountability court.
Gotcha. I can have it sent to Ms. Hall today.
Okay. All right. So what I'm going to do, Mr. Lewis, I'm going to set a $20,000 bond in your case. It's going to be $10,000 for count 1, and then $5,000 for each of counts 2 and 3. I will make that a signature bond through pretrial services, level 1, which means you'll be checking in with them via telephone pretty regularly. You will be required to live with Ms. Hendricks at the address that Ms. Patel shared. Can you give us that address again, Ms. Patel?
Yes, Your Honor. It's 127 Nottingham, Nottingham Way, Osceola, Oscilla, Georgia, 31774.
Yeah, I think Oscilla is Ocilla. But either way, people will know where to find it. We've got the street address. So you'll be required to live with Ms. Hendricks, Mr. Lewis. If for some reason you want to move or you need to move, you got to clear that with pretrial services Of course, you won't be living with Ms. Hendricks if you get into drug court. You will, it sounds like you'll live with your mom on Holly, but that will all be coordinated through drug court and pretrial services. You don't have to worry about that. But you do need to stay plugged into pretrial services. If they can't find you and you're not checking in with them, they will come off your bond and you'll need to take out another warrant, and then you'll be stuck where you are right now. And I'm going to require you to have no violent contact with Ms. Hendricks.
Yes, sir.
And you need to complete your drug court intake interview no later than August 14th.
Yes,
I
sir.
hope you can do it a whole lot before then, but you need to get that taken care of no later than August 14th. So if that date is approaching, you need to start working the phones with the folks at drug court so that they will chat with you.
Yes, sir.
Anything else, Ms. Hall, you want to see as a condition of bond?
Nothing else from the state, Your Honor.
Mr. Lewis, I'll sign that bond order today. You may not get out today. If you are still in jail on Wednesday, you should reach out to Ms. Patel so we can figure out what the holdup is, all right?
Yes, sir.
How are you going to get to Osceola from the county jail?
I'm calling Ms. Contrusta.
Call what?
I'm calling Ms. Contrusta when I get out.
Who's Mr. Trusty?
Ms. Hendricks.
Ms. Hendricks.
Ms. Hendricks, okay. And Ms. Rolak, is Ms. Hendricks willing to drive all the way from Osceola to pick this guy up?
Are you gonna come pick him up? She said that she and his sister worked it out and they will get him on Greyhound.
Okay. One way or the other, he'll make it down to Osceola.
Yes, sir.
All right. Do you have any questions, Mr. Lewis?
No, sir.
All right. And Ms. Patel, there are no bond issues with these 3 shopliftings?
I'm on a signature bond on that, sir.
Well, you're just the king of signature bonds. All right. I'll let you know this. If you get arrested while you're on the signature bond for this case, I'll revoke the bond until we're done with this case, all right?
Yes, sir.
All right. Thank you.
Thank you, Ms. McBurney. Thank you, Ms. Patel. Thank you, Ms. Hall. That's it.
All right, Ms. Patel, so you'll take care of the referral form and we'll go from there.
Yes, Your Honor.
Okay, Candy, you ready?
Are you Mr. Gordon?
Yes, sir.
All right. Is this your case, Ms. Patel?
No, Your Honor, this is actually going to be Mr. Franklin.
I'm here.
Hey, Mr. Franklin, good morning.
Good morning.
How is this your, I'm fine that it's your case. I just try to understand the mysterious ways you guys move around. This seems in anonymity.
Per the regular assignment stuff, this would have been Ms. Patel's case. However, I represented Mr. Gordon before. So when we saw he was on the calendar, I just reached out to Ms. Patel and told her I would look into it since he and I had a relationship before.
Makes a lot of sense. All right. So Mr. Gordon, I'm Judge McBurney. I don't think we've met before. I've got down here that you have a probation revocation matter. I'm going to look your case up while we're talking, and we can figure out what we're going to do today. I also have a note about a related case, but it's not your name, Mr. Gordon. I don't know what that is. Let's find your case. All right, here's your case. You got a cocaine charge, and here you are on a revocation.
So if you recall, Your Honor, the last day that we were in court, and I informed you that I had this other matter for Johnson County going on, I also made mention that Mr. Gordon's case, the nature of the new offense are allegations of shooting. I believe
You weren't supposed to be here. Why? How did you make this call?
they have another hearing going on, so I'm actually on Zoom on my phone, but I'm on WebEx on my computer. So I'm just looking at both screens and seeing which one opened up first.
Okay. Well, thank you for plugging in. I forgot that you had that other conflict. Okay. So there are new. I see. Here's the CP case. This is exactly what you said. So let me talk for a minute, Mr. Gordon, and then you can let me know if this is your understanding of the situation. You have some new charges that are potentially serious. There are just allegations right now. We're not going to get back to them. But what I'm remembering Mr. Franklin telling me is that based on the nature of those charges, we were going to put the brakes on your revocation and wait to see what happens with the new charges. Is that your understanding, Mr. Gordon, of the plan?
Sure.
Okay. And Mr. Franklin, is that still how you and Mr. Gordon want to handle things?
You cut out at the very last second, so I just heard Mr. Gordon's name, sir.
Okay. I was wondering, Mr. Franklin, if this is still how you and Mr. Gordon wanted to handle things.
That's correct, Your Honor.
Okay. Let me look up this one other case that's listed on the calendar. Okay, and I guess there's a case 18 SC 160000, and it's State versus Kenneth Willis, but it says AKA Gregory Gordon. It looks like that's closed out, so I guess it's just lurking around out there. If there's probation on it, I don't know if it's null process. All right, we don't need to worry about that one at all. Just want to make sure we don't leave any loose ends. So we've got this case where there is a revocation matter, but we are going to put the brakes on that to see what happens with the new charges. I don't want to lose track of this, Mr. Franklin. Should we put it on an inquiry calendar? And you tell me how far out, or what's your suggestion?
Inquiry calendars are fine. I mean, I guess the bigger hurdle is going to be the fact that we don't know when cases are going to be indicted again. So if we were to have an inquiry calendar in a month or 2 months, it would be a good way just to make sure that, Mr. Gordon is having any issues addressed. If he has questions about the process or anything, just to make sure he has a forum available for us to address whatever things may come up. But I guess there wouldn't be any significant movement until, I guess I've heard the earliest may be October, November, when grand juries meet again or something. So.
Okay. Then what we'll do is put this 2 months out. If we need to meet sooner, Mr. Franklin, let Ms. Nelson know. But otherwise, we'll put it a few months out, and maybe at that point decide whether we roll it again, or the state may say, if we want to go forward with the revocation hearing, it would be an evidentiary hearing. We need to see what state of affairs we were in then. Ms. Hall, do you have any objection to putting this on an inquiry calendar in mid to late September?
No objection, Your Honor.
Okay, well, let's do that. Mr. Gordon, we are not forgetting about you. If something comes up with your new charges that changes the situation, Mr. Franklin will let us know that, and we'll get you back on a screen or in here in court to talk about your case, okay?
Okay. And I'm gonna come see you on Wednesday, Mr. Gordon, so we can talk in more detail then, okay?
Okay.
Any questions for me, Mr. Gordon?
No bond, no nothing right now.
We're not getting a bond on this, given those new charges. You also don't have a bond on the new charges, probably because of this, so you're caught in a little bit of a loop. But Mr. Franklin's gonna come talk to you on Wednesday, and I bet that's gonna be one of the subjects you all discuss. And if there's something Mr. Franklin thinks he ought to do in that area, I'm confident he'll do it, and then we'll get back together, okay?
Yes, sir.
All right, thank you, Mr. Gordon. All right, Mr. Knowles should be next. Are you Mr. Knowles?
Yes, sir.
How you doing this morning?
I'm all right. And yourself, sir?
I'm also all right. Good to see you. Mr.
Good to see you
Knowles,
too.
you are on our calendar for plea and arraignment. Ms. Patel, is this your case?
Yes, Your Honor.
Great. Are we doing something beyond a waiver of arraignment for Mr. Knowles?
Your Honor, we'll do a waiver of arraignment and we'd like to address his bond.
Okay. Ms. Hall, are you in a position to go forward with bonds today?
Yes, Your Honor.
All right. So Mr. Knowles, first, Ms. Patel's going to file some paperwork that gets your case formally moving along, this waiver of arraignment form. She'll get a scheduling order. That's going to let you know when your next court dates are. And that'll take care of the administrative things. The other thing we're going to do today is talk about bond. Ms. Patel's going to let me know why she thinks you ought to get a bond and what that bond should look like. And then Ms. Hall, who's the prosecutor handling your case, is going to give me her perspective. She may agree, she may disagree, and then I'll let you know before we're done with this session how we're going to handle it, okay?
Yes, sir.
All right, Mr. Forte, you ready?
Ready, Judge.
Great. This is position 4 on our calendar. It's indictment 20 SC 175827. State versus Rodney Knowles. Mr. Knowles is charged with aggravated battery and simple assault. And we're going to have Ms. Patel explain why Mr. Knowles should get a bond and what that bond should look like.
Thank you, Your Honor. Before you is Mr. Rodney Knowles. He has been in custody since January 27th, 2020 on these charges. This is the first time he has been in front of Your Honor to have his bond addressed. This is an incident involving someone that lives in the neighborhood. I do not have a complaint packet. However, it appears as if a fight occurred between my client and this gentleman. My client does not have any felony history. This is the first time he has ever been charged with a felony offense. He is 35 years old. He has a GED that he obtained in 2013. He's a lifelong resident of Atlanta. Prior to his arrest, he was working in landscaping part-time. If he were to be released on bond, Your Honor, we would ask that it be a signature bond. At this point, my client has been in custody since January. I don't believe he has the funds to put any money down towards bond. We would be agreeable to any conditions placed on a signature bond through pretrial services. He could do level 3 reporting. While there is an issue with the fact that the complaining witness lives near Mr. Knowles, a stay away could be put in order to ensure that they do not come across each other. And so I was hoping that perhaps we could resolve this case today, but it doesn't seem like we will be able to do that. With that being said, I do think that we could potentially resolve it in the future.
Okay. Ms. Crawford, Ms. Patel said that Mr. Knowles has no Georgia felonies. Does your research support that?
That's correct. I can't find any records on him.
Okay. Ms. Hall.
Thank you, Your Honor. Just give you short facts in this case. This is a very, there was a noise complaint from the defendant. Apparently there was noise going on. He went to the victim's house and just attacked the victim. I spoke with the victim myself, and he is at this point terrified of this, the defendant. He told me that the defendant is someone who terrorizes a lot of people in that neighborhood, who is a bully in that neighborhood, and a lot of people are afraid of him. They feel safe right now that he's locked up. There is a victim impact statement. I think it's fairly short that Ms. Rolak can read to you at the court's pleasure. But I also had the chance of speaking with the defendant's mom this morning, who also informed me that he shouldn't get a bond because he's threatened the victim in this case multiple times, along with the family in this case. And he said for sure that if he gets out, he's going to do something to that entire family. She said that she knows this for sure because obviously this is her son and she's seen him do things before. She didn't go into details as to what those things were, just that she wanted us to know that he should stay where he is because that family is in some type of danger. She don't know what kind, but that was her advice. Mr. Like I said, he said that the defendant, he didn't know what happened that day. He just came over and started to punch him. He had to have surgery on his jaw after he was attacked by the defendant. And now he's even afraid to go outside to burn wood inside of a barrel that he usually burns and talk to his friends around. That is all as far as state's position. With gathering all the information, Your Honor, obviously our position is that he remains in a no bond status until this case is worked out. I don't know how we'll be able to work this case out. I did learn from the mom this morning, the defendant does not live on that street. He actually is homeless. He was sleeping on a cousin's porch, and that cousin will no longer allow him to sleep there. So there may not be an issue as far as him going home and being on the same street because they live about 3 houses down. But there may be an issue of the defendant knowing exactly where the victim and his family lives in this particular case. But other than that, we just have the victim impact statement, Your Honor.
Okay. Ms. Rolak, are you ready with the victim impact statement?
Yes, it's fairly short. And just so you know, Judge, both the victim and the defendant's mother are following the YouTube live feed.
Make sure I heard you correctly. So Mr. Mitchell is following, and then you're saying Mr. Knowles' mother is, or Mr.
Yes,
Mitchell?
and her name is Patricia Bailey.
That's Mr. Knowles' mother?
That's correct, Judge.
Why would you know that Mr. Knowles' mother is following it?
Because I received a call from her this morning after I spoke with the victim.
You received a call from the defendant's mom after you spoke with the victim?
That is correct, Judge.
What did the defendant's mom say to you?
Exactly what Ms. Hall said.
Right, that's who I was referring to, Judge. I'm sorry if I missaid who I was talking to. Ms. Bailey is the defendant's mom. That's who I spoke with as well.
Oh, I thought you were saying this was Mr. Mitchell's mom. So
no.
The person who you said described Mr. Knowles as a bully and sleeping on his cousin's porch. That's the defendant's mom who told you that?
No, it's two separate things. So the person who said he's a bully in the neighborhood was the actual victim, Mr. Mitchell. But then I also spoke with the mom who said that, yes, he's sleeping on the cousin's porch. She knows that her son is going to hurt these people because she knows her son and he's done things in the past. He's threatened the victim and his family. She was just urging us to keep him where he is because she knows that something's going to happen if we release her son from jail.
Okay, I thought this was Mr. Mitchell's mother, but
no, I'm sorry, Your Honor. No, the defendant's mom.
Got it. And that's Ms. Bailey, and she is also following what's going on, and she's entitled. Right. So Ms. Rolak, what you have is a statement from Mr. Mitchell?
This is correct.
Okay, please share.
On the date Rodney Knowles was arrested, he had attacked me for a disagreement we had. As a result, he caused severe damage to my right eye, which required surgery. He has since threatened me and my family. He said this once he is released. Calvin Mitchell.
All right, well, thank you, Mr. Mitchell, for sharing that. Ms. Patel, I need to rewind a little bit. Tell me where it was. Here's what I recalling you shared with me about Mr. Knowles. No adult felony criminal history, confirm that. He got his GED. He's been doing some landscaping work. He's an Atlanta native. These all are good things for him in terms of getting a bond. Where was it that you were suggesting he was gonna live?
So we believe that he could return to his cousin's house. I will have to follow up with his cousin. I don't believe his mother resides there, so I'm not quite sure what her connection is to this case other than being his mother.
Okay, well, that's not a disconnection.
Sure.
Her input as well. What I'm gonna do is defer ruling right now. I would like Ms. Patel, if you could follow up on where it is you believe Mr. Knowles would be permitted to stay. So get confirmation of that. Share that with Ms. Hall and Ms. Nelson. And then Ms. Hall, if you would share with Ms. Nelson Mr. Mitchell's address. I need to see how close these are together, and I need to see how viable the cousin's address is. And if I decide that that's not the place where Mr. Knowles ought to be staying, then I want to give you, Ms. Patel, an opportunity to find another location that might be, one, more stable, and two, further away from Mr. Mitchell. But I appreciate Ms. Hall and Mr. Mitchell, since you're listening, that one of the concerns is not just distance, but the fact that Mr. Knowles knows where Mr. Mitchell lives. So Mr. Knowles could end up identifying an address in Stone Mountain, which is certainly much further away from Mr. Mitchell's residence, but that doesn't erase from Mr. Knowles' memory where it is that Mr. Mitchell lives. So I'm trying to strike the right balance. I am hearing loudly and clearly Mr. Mitchell's concerns and what Ms. Bailey has to say about Mr. Knowles. But I'm also noting that Mr. Knowles has a clean record as far as we measure the record. I know that's limited, but certainly give it a lot of weight if there are convictions. I ought to give it weight if there are no convictions. So I want to strike the right balance that would keep Mr. Mitchell as safe as possible, but would also reflect the fact that Mr. Knowles is, of course, presumed innocent, and he does not have a criminal history that would suggest that he goes around breaking people's jobs or whatever the allegation is here. So I'm not in any way minimizing what happened to Mr. Mitchell, but the way it's been described to me right now, I'll need more info about the proposed address. And if that address, in my mind, doesn't work out, then Ms. Patel, you and Mr. Knowles can look at alternative addresses and let me know. Okay?
Okay.
Your Honor.
Anything else on the Knowles matter?
Yes, Your Honor. I just received a message from Ms. Rolack that Ms. Bailey wanted to speak. If I don't know if that's appropriate or not, now that you're done with your ruling, but she wanted to answer some of your questions or concerns that you may have.
So I'm comfortable hearing from Mr. Mitchell. I'm not comfortable hearing from Ms. Bailey, but I think right now what you've relayed is sufficient, Ms. Hall, from Ms. Bailey, especially now that it's become clear to me that you were referring to Mr. Knowles' mother and not Mr. Mitchell's mother. That, to me, makes the concerns have more basis. I don't know why Mr. Mitchell's mother would know a whole lot about Mr. Knowles, but Mr. Knowles' mother stands to reason, knows a fair amount about her son. If there's more that Ms. Bailey wants to relay to you, Ms. Hall, that you ultimately want to get, probably going to need to reconvene to talk about a possible residence for Mr. Knowles. So when we do that, that might be an appropriate time for you to share more. I am not signing a bond right now, and I won't until we talk more about where Mr. Knowles might safely reside. Okay?
Thank you, Your Honor.
Great.
Thank you, Judge.
Thank you, everyone. I think Mr. Turner is next. And someone mentioned there was an add-on. Does anyone know, or was that a mistake? Is there a position 9? I don't have it.
William Pearson.
Okay. Do you have a case number for that, Ms. Hall?
It's 20 SC 174339, and that's Ms. Patel's case.
All right. And just thumbnail, what are we doing with Mr. Pearson, Ms. Patel?
Bond argument, Your Honor.
Okay. I'll be ready for that, assuming that the jail has him there. But you're Mr. Turner, is that right?
Yes, Your Honor.
How you doing, Mr. Turner?
I'm doing good. How about yourself?
I'm doing okay. Mr. Turner, I've got you down here for arraignment. We had a bench warrant for you. You're charged with aggravated assault and embarrassing threats, but you have some new charges too. I want to quickly look up.
Theft by receiving stolen property, Your Honor.
Always want to spoil the surprise.
Sorry.
Theft by receiving stolen property. Okay, you're exactly right, Ms. Hall. Okay, so Ms. Patel, tell me what the plan is for Mr. Turner for today.
Your Honor, we are asking to address his bond, and then we will waive arraignment and have the case move forward.
Okay, so you'll file the waiver of arraignment. Ms. Nelson will push the scheduling order out, and we'll do what we can with these charges, which seem, at least on paper, more serious than the CP case. And that might be one, depending on how this case sorts out, that we could move along with it. Okay, Ms. Hall, are you comfortable talking about bond today? Not in, I guess we need to. I haven't forgotten you all, I'm just looking to see. Okay, so there's already a bond set in the CP case. So we are working through then whether there ought to also be a bond set in this older case. Ms. Hall, are you comfortable talking about bond in the 18 SC case?
So fairly, Your Honor, we have not been able to contact our victim. We had to do an investigative request to get a new number for, or get new contact information for our victim. That, and the numbers that we've gotten so far from that request has still been no good. I wasn't aware of a bond hearing. I can still potentially argue, but without the victim's input. Ms. Patel probably argued that it's not important, seeing as though that she testified during a bond hearing in the past, but I'm not completely ready for a bond hearing, seeing as though I have not talked to the victim.
Okay, but you're saying that there was a bond hearing in the past, and Ms. McCree is the name of the alleged victim. She testified at that bond hearing?
Yes, Ms. Patel sent me the transcript for it. She pretty much was recanting, Your Honor, the entire situation. I just be frank, that's what it was, which led us to possibly a no price. But when I researched, I'm sorry, I don't even know if we're talking about the case right now, but I haven't talked to her to confirm that situation or anything other than that.
Okay. All right. Why don't we at least start the conversation? And if I feel like I need to hear from Ms. McCree, then I'll give you some time to try to track her down. And if not, we'll go from there. Let me look. So Mr. Turner got a bond in this case when it was a CP case. Okay, so here's some notes on a bond order from August of 2018, so about 2 years ago. Ms. McCree testified in July of 2018. She advised she did not want to prosecute. She was not in fear of the defendant. She would like him released. And Ms. Bray of the Public Defender's Office had a transcript of the bond hearing and shared it with Judge Woodson. And the VA's office did not concur with that bond. And there's kept being reduced because it had not been indicted. It had been reset 4 times, and the magistrates finally got fed up. So I guess he got a signature bond or some kind of bond. And then what happened, Ms. Patel? I guess Mr. Turner didn't come to court and there was a bench warrant?
Yes, Your Honor.
Okay. All right, well, let's start talking about bond. We see if Mr. Forte is ready. He's rubbing his hands in preparation. He's ready.
Ready, Judge.
Great. Okay. So this is position 5. It's 18 SC 161935. State versus Quintavious Turner. Mr. Turner is charged with aggravated assault, terroristic threats, and simple battery. And Mr. Turner at one time had a bond. He didn't make it to court and had his bond taken away. A bench warrant was issued. And Mr. Turner has since been arrested. He has some new charges for theft by receiving. Those are not before us today, and Mr. Turner has a bond on the charges. Ms. Patel.
Thank you, Your Honor. Before you is Mr. Turner. He is a high school graduate. Prior to the pandemic, he was working as a mover for SNC Movers part-time. He failed to keep the court updated on his new address, which is why he failed to appear at his court date once his case had been indicted. With regards to this case, Your Honor, the complaining witness did testify under oath that she did not want to prosecute, that she is bipolar and does not take her medication, that she was the aggressor in this case, and that Mr. Turner was attempting to restrain her. The state talked to an alleged witness to this incident, which appears to be why we haven't been able to make any headway in terms of coming to a resolution, is based on this witness's testimony. But the victim is not in fear of him. They are not together. They have not been together. He is with another individual and is expecting a child with her soon. And so we would ask that a signature bond be put in place for Mr. Turner through pretrial services level 3. And I do have an address in which I could provide the court should he be released on bond. And just to note, Your Honor, on his previous arrest, he did spend 125 days in custody before he made bond on that case. And so we would ask for signature bond through pretrial services. I don't believe that Mr. Turner would have any money to put towards a bond.
Okay. One second. So the CP case, the theft by receiving, I'm just looking at that to see what has happened, because in theory, with these charges pending, meaning the aggravated assault charges, Mr. Turner's picked something new up. It sounds like he had allegedly, he had a rental car, maybe beyond its due date. But that's it. So, Mr. Turner, you are, do you have any kids?
Yes, I'm not expecting a child. I had a child February the 21st. My son,
I apologize. That's
my son is 4 months here, 4 months old. I mean.
Okay, when did you get arrested on the bench warrant? How long have you been in?
Since June 21st, Father's Day.
Oh, you got arrested in the rental car and you've been in since then?
Yes, doing Uber Eats.
Okay, so you've seen your son, you got to hold your son for a few months, and then you got arrested on the stolen car case and that's when this bench warrant caught up with you.
Yes, it popped up when I was booked in.
Okay, so you've got one child, your son?
And a stepson, 4 years old, that I
Okay.
take care of.
Ms. Etchison, the mother of your child?
No. Oh, yes. Tatiana Edson.
Yeah, how do you spell her last name?
Etchison.
Etchison, okay. And that's the mother of your child. Is she also is her other son who's your stepson?
Yes, sir.
Okay, got it. And is her house where you go live?
Yes, I still have my sister address where I was living, but recently I've been at my baby mother's house. So
But you need to pick one spot if you're on pretrial release. Which spot would it be?
654 Boulevard, Northeast, Atlanta, Georgia, 30308.
Is that Ms. Etchison's place or your sister's place?
My Miss Etchison.
Okay, so your sister lives on Manor Terrace?
Yes, sir.
Okay, but you would stay with Ms. Etchison and your two kids?
Yes, sir.
How did you know Ms. McCree?
Met her in some apartment that I am no longer able to go to.
Okay, so wherever she was living 2 years ago, that's not a place you go around anymore?
No, I have no idea. I ain't seen her since then.
Okay, and that's not anywhere near Boulevard?
No.
Okay, all right. How long have you known Ms. Etchison?
2 years.
Okay. And how are she and your little boy doing?
Maintaining right now due to the unemployment, due to the pandemic, but I'm most likely the breadwinner.
What kind of work are you gonna try to get back to doing, moving?
Yes, sir. My bosses are very understanding, so I had already reached out to them.
All right, good. Ms. Hall?
Thank you, Your Honor. Your Honor, the state's position is that the defendant remained in a no bond status. When he was arrested for this case, he already has an open case in our office for a burglary in the first degree. This case, I found out through our witness, although the victim is recanting as they do in these domestic violence cases, I spoke to an independent witness that knew neither the defendant or the victim in this case, a 66-year-old woman who witnessed the defendant pretty much attacked the victim during mid-broad daylight, 5 o'clock. It was during 5 o'clock rush hour time. So she said plenty of people were outside. Multiple people called 911. She tried to intervene multiple times, and she said at one point the defendant even hit her. She said that during a lot of the times when she tried to stop him from attacking the victim, he would cuss her out and try to degrade her, but she was just there like trying to protect the victim. I don't know how the victim feels in this case, but it's our job to protect them. And I know for a fact that, I know that the defendant has moved on to someone else, but this still happened in this case. And when this happened, he had an open case. He's picked up another case since then, and he had 2 or more FTAs. So it's our fear that, Your Honor, if he is released on bond, he's either going to reoffend or he's not going to show up to court.
Tell me about the burglary case. I don't see that in the mix here. Is that now closed? What's that case number?
It is 17 SC 153423. That disposition date was February 13th, 2018. And he has, I believe, 2 years and 6 months left on that case.
So he was on probation for that case when the incident in this case allegedly occurred.
Right.
Got it. Okay. Ms. Crawford, I should have asked you, are there any other open cases for Mr. Turner?
There are no other open cases except the one that Ms. Hall is referring to, the 17 SC 153423 case. He has 2 years, 6 months and 15 days remaining on that case.
Okay. And was there ever a revocation in connection with this case?
I think I checked, there wasn't one, but let me double check to make sure.
Okay.
And no, Judge, he's never had a revocation on this case.
Okay. Yeah. So, Mr. Turner, you present a complicated situation. There's part of you that seems like a good candidate for bond, and there's part of you that is kind of tricky to work through. While on probation for the burglary and on bond / on bench warrant for the aggravated assault, you picked up yet another set of charges. So there's sort of these 3 different cases swirling around. There ought to be a revocation petition for you for the burglary case, either because of the aggravated assault case or this new theft by receiving allegation. There was a bench warrant because you didn't keep it posted as to your whereabouts. And then there are these new charges. Ms. Hall, you shared with me that you spoke to a witness, in theory, an independent witness to the assault that Mr. Turner is alleged to have made on Ms. McCree. You spoke with this person and this was recently, or your office spoke with this person back in 2018?
I spoke with her last week. I spoke with her again yesterday. She works at City Hall and she remembers the case as if it happened yesterday, and she's all for coming to court and everything. So just recently, yesterday.
All right, well, it's good to have concerned citizens. So, Mr. Turner, for now, I am not going to set a bond, but I am mindful of the fact that the state has not been able to locate Ms. McCree, and that's going to make it complicated for the state to move forward. So what I'm going to ask, and it sounds like Ms. Hall's already started it, she's put in a request to her investigator, but I'm going to give the state some time to try to track Ms. McCree down. Not so much so she can either repeat herself by saying it wasn't Mr. Turner's fault or I was the aggressor, but more so to confirm that we can track her down. Because if we can't, then one, I'm less concerned for her safety in connection with you, and 2, I begin to worry about whether the state could move this case forward, and maybe we ought to get you out. But you've got an open probation case. You've got these charges and then these unindicted charges concerning the rental car. And that's enough for me to say you should stay put until we get some clarity on one or more of these situations. So Ms. Hall, if you could get a report, please, to Ms. Patel and to Ms. Nelson within 3 weeks as to your investigator's success in tracking Ms. McCree down. That'll be a tickler for Ms. Patel to say, we need to have another conversation about bond, whatever the outcome of your investigator's work is, okay?
Okay, thank you, Your Honor.
So 2 things, Mr. Turner. 1, your case is going to keep moving along. The prosecutor has an obligation to get discovery in this case to Ms. Patel. So it sounds like Ms. Patel has a pretty good idea what the allegations are. And one of the biggest questions is going to be, where is Ms. McCree and what does she have to say about it now? 2, we'll revisit this question of bond in the not too distant future. And I guess I should add 3. There's also a possibility that you and Ms. Patel will keep working on a way that would resolve possible revocation, your burglary case, these charges, and the rental car case, and wrap everything up into one. If that's the right next step. And I'm not saying it is, but that's something I'm sure Ms. Patel will be talking to you about. Ms. Patel, anything else in Mr. Turner's case?
No, Your Honor.
Ms. Hall?
Nothing from the state, Your Honor.
All right, thank you. So I've got two left. I got Mr. Thompson and Mr. Pearson. Are you Mr. Thompson?
Yes, sir.
Are-
Excuse me, Your Honor. Your Honor.
Yes, sir.
We don't have the ad on for Pearson. Do y'all actually need the body? Because I'm just hearing about this for the first time from you.
Me too. Let me find out. Ms. Patel, did Mr. Pearson waive his presence?
No, Your Honor, when we had calendared it, we had asked to have him present through Zoom or in person.
And I guess he's in custody if we're talking about.
Correct.
Well, maybe Ms. Nelson can share some information. The calendar I've got, which I assume is the calendar the jail has, is with Mr. Walker, position 8, and we've already taken care of him. So let's see what the jail's able to do. But if they didn't get the calendar, I'm not going to hold them liable for not getting Mr. Pearson to us, and we'll just figure out a way to get Mr. Pearson on the screen in the near future.
It was sent by email, a request to add him on. I don't know if I actually received an email back confirming. So I will have to put him on another calendar and make sure that I put him on an actual calendar and not per email.
Okay. Sounds good. Well, let's work through Mr. Thompson's case. Mr. Franklin, you handling Mr. Thompson's case?
Yes, sir.
All right. I've got it down for plea and arraignment. Are we doing anything else?
Not at this specific time, Your Honor. What I will ask is, I've not been able to make contact with the complaining witness. I'm not sure if the state has. I will ask for a 2-week reset to try to figure out if they can get hands on him. I understand through other communications with persons other than the complaining witness that he may not want to prosecute. And that would certainly be relevant information for the purposes of bond. However, Mr. Thompson does have a foreign county hold, which I do believe is just kind of a city ordinance violation situation. I think it's like drinking in public in Forest Park. He also has a pending probation hold here in Fulton County for a 2008 burglary. As best as I can calculate on my own, I think that he may have 2 or 3 years left on that. If Ms. Crawford has any more specific information, I'd like to know that information. And I've also disclosed to Ms. Hall that we're still in need of medical records.
Okay. Yeah, I'm looking at the indictment. So Mr. Dennis Lawrence is the alleged victim who was struck with, it says, a stick. And is that someone who is a stranger to Mr. Thompson or someone?
No, they're friends. They've been friends a long time.
Okay. All right. So you'll do a waiver of arraignment for Mr. Thompson?
I completed that in court when I was in court with you the other day. That's one of the 2 that I handed you.
You did, and here it is in the record as of the 16th. So that's all set. So we'll get a scheduling order out, and then it sounds like Mr. Thompson, we'll get you on the next one of these Zoom calendars that we do to talk about bond. And between now and then, the state's going to do what it can to try to track down Mr. Lawrence. It sounds like Mr. Franklin will be doing the same based on what he's hearing on the street. And we will talk about bond then. The state will have had 2 weeks notice to be ready on that. And I guess we could add, if we're not going to see Mr. Pearson today, Mr. Pearson could be on that calendar as well, just for everyone's planning purposes. Because I don't think we get a Zoom calendar more frequently than that. Anything else, Mr. Franklin, on Mr. Thompson's behalf?
No, Your Honor. Mr. Thompson, I plan on being up there by Wednesday to come speak with you in person. So just hang tight for me.
The probation case is with what judge, do you know?
It's a non-complex charge.
Okay, so it's something we can handle if we need to.
Yes, sir.
Okay. All right, Ms. Hall, anything on Mr. Thompson's case?
Nothing from the state, Your Honor. We are still waiting for the medical records and the rest of the discovery to come back from APD, but nothing further from us.
Okay, so Mr. Thompson, it sounds like we may be seeing you again in a couple of weeks to talk about bond. You'll certainly be seeing Mr. Franklin in just a couple of days to talk about your case, all aspects of it. And then the prosecutor is working to get more of the discovery in the case, which of course you're entitled to. It'll go to your lawyer, and then your lawyer will share it with you. Medical records for the gentleman who was allegedly injured in the case, and anything else that the police would have gathered as part of their investigation. That'll be something you and Mr. Franklin will talk about, and will help shape your decision as to what you're going to do next. Mr. Franklin, anything else for Mr. Thompson?
No, sir.
All right, Mr. Thompson, it was nice meeting you, and I may see you in a couple of weeks, okay?
Thank you.
Thank you. All right, I think that's it. Ms. Hall, anything else from the state?
Nothing else from the state, Your Honor.
Hold on, I got one email that I was supposed to maybe ask you guys. I don't forget anything.
I got one reach out.
No, I don't think so. Okay, Mr. Franklin, anything else?
Not at this time, Judge.
Okay, you got all dressed up for the habeas thing.
I'm gonna take two and.
Yeah, you know, better to be overdressed than underdressed.
All right, good luck with that whenever it happens.
Thank you much.
Ms. Patel, anything else?
Nothing further, Your Honor.
Ms. Snyder, are you still with us?
Yes, sir. Nothing further.
Okay, it looks like tomorrow we've got a few bond hearings and then a status conference and a motion to suppress. Is that still happening?
Yes, Your Honor.
Mr. Franklin?
I'm prepared to go forward. I've not been able to reach my client by phone. His phone was not in service. How to make a call to some other numbers today to speak to him directly.
Okay. And is that something that we're doing here in court, or is it a Zoom thing?
I plan on being physically present. We would ask the officers are physically present. I haven't been able to talk to the client, of course, to know what his preference is, or if he would express that he's not comfortable coming in, and I make the request that the officers physically come in, that, you know, wouldn't necessarily be equitable. And we may need to talk about if it needs to be scheduled for a different time or something. But as of this moment, I'm prepared to come to court and handle it.
Okay, I'll be here either way. I was just curious. We haven't had an evidentiary hearing yet. We'll be doing different. All right. Well, please let Ms. Nelson know as that unfolds, Mr. Franklin. Anything more from courtroom 2? You guys good to go?
Hi, Judge McBurney. We finished?
I think we're done. I think you got us, everyone. Thank you so much.
You're welcome. It's good seeing you again.
All right. Take care.
Bye, everybody.
All right. Till tomorrow, everyone. Bye-bye.
Bye.
Bye-bye.